You are now you file an application. That's not the way.
I have come only in regard to 15th March. Kindly appreciate.
No, Mr.
I have no problem in declaration
you.
of the list of donors or the list of recipients.
Mr. Rodgi will not hear you right now. We have a specific application on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a.
No. I am saying kindly.
If I do it for Mr. Rohatgi, senior counsel, then Mr. Rohatgi, you look at me as Chief Justice. I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What sauce for the goose is sauce for the gander.
I'm not mentioning. I am not appearing in the matter and making a submission.
We have no such application on board before us.
I have got it with.
I have made my.
The entire judgment has.
Second, you wait. One at a time. Sorry, Mr. Rodgi. Yes.
No, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute justificator. This judgment doesn't constitute justificator.
1 second.
Yes.
1 second.
This judgment is void.
Please listen to me. You are 1 second.
I am a citizen of this country.
1 second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No,
file an application. What I told Mr. Rodgi applies to you.
No, my lord, the question is, my lord,
there's no question. You've got
my friend has come.
Mr. Nedumbara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No further.
We will go by what your lordship.
All, please.
Whatever your lordship says, we will go by that.
Do you want another contempt notice?
No, my lord, your lordship will go by
You have
whatever
had
your
enough
lordship
to
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't constitute. It is not a.
Do not, please, once we have said no, please move the application by email.
What your lordship says.
Do not continue and persist.
Yes, I only said it was not a representative proceeding.
You are
All the way come from Kerala.
You are obstructing in the administration of justice.
Hello, my lord.
You are obstructing in the process of administration of justice.
The entire judgment is against behind the back of these people. Parliament has been rendered irrelevant.
That's all. That's all. We heard our, please, that's all. You made it. We will not hear you till you follow the procedure prescribed.
We are filing it.
Please do.
We are filing it.
Please do. We'll consider it afterwards.
That's
That's
it.
it.
10 o'clock. My friend came from Kerala to took a 1 o'clock flight. Be kind to us. Be kind to
That's
us.
all, please. We will not hear that. Please
Democracy.
call for the application. Please follow the application.
My lord, may I mention, my lord, my petition for so moto that is pending. Whatever lordship want to do, that do only. I will not disturb lordship.
Mr. Agarwala, apart from being a senior counsel, you are the president of the SCBA.
Yeah.
You know the procedure. You have written a letter to me asking me to invoke my suo moto jurisdiction.
Yes, my lord.
No locus to mention
So that
anything.
I should not disturb lordship. We should not waste it honorable time, court's time.
Fair
That's
enough.
why.
Lord,
Only that.
These are all publicity-oriented stunts. We will not permit it.
Whatever lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful. Please close it.
It is enough now. It is enough.
Justify your old man, Lord.
Be kind to us. We are very polite and begging with your lordship. Your lordship has a soft language.
We have been telling you that you are interfering, you are obstructing us.
No.
Now, if you don't stop, we will have to.
When we are not heard and we feel threatened. For you, Lord.
Follow the line.
Yes, Pala. Yes, hearing now. We should notice on the last occasion to State Bank of India. Mr. Kapoor, you are appearing? You are appearing for the State Bank?
That's it.
Yes.
But I appear for the State Bank.
Yes. Mr. Salve, in our order which we, in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So, let SBI not be selective in the disclosure of details. We intend to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
But I just what
You are now you file an application. That's not the way.
I have come only in regard to 15th March. Kindly appreciate.
No, Mr.
I have no problem in
Rodgi,
declaration
you.
of the list of donors or the list of recipients.
Mr. Rodgi will not hear you right now. We have a specific application on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a. We'll get it. No.
I am saying kindly.
If I do it for Mr. Rohatgi, senior counsel, then Mr. Rohatgi, you look at me as Chief Justice. I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What sauce for the goose is sauce for the gander.
I'm not mentioning. I am not appearing in the matter and making a submission.
We have no such application on board before us.
I have got it with.
I have made my.
The entire judgment has.
Second, you wait. One at a time. Sorry, Mr. Rodgi. Yes.
No, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute justificator. This judgment doesn't constitute justificator.
1 second.
Yes.
1 second.
This
1
gentleman is
second.
poet.
Please listen to me. You're
It
not,
is-
1 second.
I am a citizen of this
1
country.
second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay?
Whatever your lordship say, if your lordship say bond numbers, you can disclose the bond number. There's no problem.
Tell us
Somebody
one-
can screen them. And
Why has the SBI not disclosed?
how we understood your lordship's judgment? Give me 5 minutes only to explain our conduct. We'll, of course, if your lordship say give anything more, everything will be given. But there's no question.
SBI's attitude appears to be, you tell us to disclose a particular detail and we'll disclose it. That's not fair process.
But how we understood-
The SBI requires, this is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, I mean, State Bank of India has the best legal advice open to it.
May I not take your lordship through the 3 orders, so how we understood them? My lord, your lordship's first order was 12th April 2019.
Yeah.
And we have, for your convenience, my lord, we have put the 3 orders together. If your lordship just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, my lord, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order, my lord, in paragraph 16,
Salve was relating to the political parties who had to submit the data to the
correct,
election commission.
correct. And they have, and this has,
No, that's a separate issue. Whatever they have declared or not declared, that's a separate issue. But as far as the judgment of this court is concerned, because you were
Yes.
also supposed to.
I'm coming in a minute. If your lordship will just give me 1 minute, how we understood it. Para 16, with, as my lord has therefore noticed, only required the political parties to give all these details. And these details have been given, my lord. If they have not been given, that's between the ECI and the political parties. As my lord, the Chief Justice said, I'm not preparing for a political party. Then, my lord, para 17 was the mechanism. Your lordship said details will be furnished in respect of electoral bonds, the details of such bonds that may be received by a political party. Up to a date for issuing such bonds as per the ministry, that is February 19, will be submitted on or before 3rd of May 19. The seal covers will remain in the custody of the ECI. So, my lord, we had no role to play. Your lordships had put this mechanism in place. In your lordship's judgment, your lordships dealt with the diverse aspects, including the need to preserve some degree of anonymity, and your lordships will not mark that in para 125, where your lordships discuss the electoral trust as an alternative to this system. And in the conclusions, which are at para 218, if your lordships have the compilation, it would be PDF page 76.
Yes.
Your lordships will not say we direct the disclosure of information on contribution received by political parties under the Electoral Bonds Scheme to give logical and complete effect to the ruling. On 12th April, the court issued an interim direction order directing that the information of donation received from donation must be submitted by political parties. The court directed political parties to submit detailed particulars of donors against each bond, the amount of each bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date on which such credit has been made. I'm only not saying this to explain how we understood the order. So this correlation between which political party has received money from whom comes in here, because the political party says I've received so much money from so and so. Then it says during the course of hearing, Mr. Sharma said that the ECI has only collected information on the contribution made in 2019 because of para 14 indicates direction was limited to contributions in that year. Your lordship then clarify para 13 and 14 of the interim order are extracted below. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission and shield cover particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date of each such credit. The details will be furnished forthwith in respect of electoral bonds received by a political party till date. The details of such other bonds that may be received up to the date fixed for issuing such bonds, including February 19, May 19, will be submitted on or before May 19, and the seal covers will remain, etc. Then your lordships clarify, para 14 does not limit the operation of 13. 13 contains the direction in unequivocal terms to political parties to submit particulars of contributions received through electoral bonds to the ECI. Para 14 only prescribes the timeline for the submission on the contributions when the electoral bond should be done. In view of the interim order, the ECI must have collected particulars of contributions made to political parties through electoral bonds. In view of our discussion, the following directions are issued. The issuing bank shall stop issuance of bonds, which was done immediately. The SBI shall submit details of the electoral bonds purchased since the interim order by the court till date to the ECI, fully given, my lord. Details shall include the date of purchase of each bond, the name of the purchaser, and the purchaser of the bond, and the denomination of the electoral bond purchase. All these details are given. SBI shall submit details of the political parties which have received contribution through bond since the interim order till the date of the ECI. SBI must disclose each electoral bond encashed by the political parties, which shall include the date of encashment and the denomination of the bond. Now, my lord, as we therefore understood this, the political parties have come and said we have received so much from so and so. Are the details which we will give will make the database complete so that we have who purchased, when he purchased, and when they've got. If the numbers are to be given, we'll give them. There's no problem. So, according to us, the data.
Mr. Salve, I have a few questions. First,
Yes.
tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, my lord, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stated. So, at
The format in which you maintain the data on purchase and redemption of electoral bonds, in what format do you
in
store
two
it?
silos, your lordship noticed that in the next order. So, the data is maintained in two
You store
silos.
it in 3 silos. From your application, it emerges now that you do it in 3 silos. The first
No.
silo is the bond number. The
Bond
second
number is
silo
only on the bond.
purchase, and the third is the redemption.
My lord, bond number is only on the bond, and it is cannot be read except through under a UV light. That was only done, my lord, like authentication, like because it was a bearer bond. That's what was sought to
The
be.
purpose of the alpha, and second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
The
it
security feature entirely.
in the audit trail? Do you also
No, my lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question,
Yes.
how does the redeeming branch
Yes. Yes.
match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it,
Yeah.
the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
There's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the
a currency note.
alphanumeric.
Yeah.
And cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
Fourth, what is the information that you see when you scan the alphanumeric?
Malad, you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No, Malad. That's what I'm saying. That correlation was not kept. For the reason, it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one is so call it, which is open near Lordship's order. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in the. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
Malad, even in the final judgment.
Say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
Malad, your lordships.
All details.
That's why we came to.
Mr. Salve, we'll clarify to put it beyond any.
No problem. No problem at all.
We'll say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed any, you will not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains.
Details, you have to disclose all details. Let there be no, because the burden should not lie upon the court or the petitioners to say, but this one has not been disclosed. But now this has not been disclosed.
Now we'll disclose it, Malad, whatever.
We must have finality to it.
Yes, we'll do it, Malad. There's no problem. Just that this constant, the media constant beating down and the petitioners giving public interviews saying, we will take the state bank to task and we will show this and we will haul them up for contempt, etc., But we are also public institutions working in this space. And it's all right. People work, people acted on the face of this. Your lordships granted an interim order saying keep records. It wasn't at that time, Malad, subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your lordships are at that balancing interim order. Now, whether completely you should lift the privacy or remove anonymity, that's your lordships will.
Mr. Salve, the idea behind the interim order was in case a writ petition is allowed, then data should come out. And that's what exactly is required. Nothing more.
I must say so, Malad, as out of whatever, as Malad, the Chief Justice is saying, your lordship will clarify, we will give every bit of information, relevant, not relevant, we'll give every bit of information which we have. So that, Malad, there should be no feeling that SBI is interested in somehow holding something back. I only want, Malad, to share one thing. Malad, your lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing the Lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and my Lord say, give the bond number, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so-and-so, investigate so-and-so. That is, I don't think, the purpose of your Lordship's judgment. That was not what it was meant for. And your Lordship will see whatever safeguards need to be put in place.
Just one more thing.
I have 2 minutes.